Pulse chain.
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 So the big day is almost upon us. It's time for the court hearing between the SEC and Richard Hart. And if we go down to the bottom, you can see the scheduled date here of October 23rd for the hearing. Now, this was changed and extended to the 31st, which is now a couple of days at the time of this recording. And what I want to bring to you is an excellent post here by Nuclear Herbs. Now, some of you guys in the community have been keeping an eye on Nuclear Herbs because he is a attorney or former attorney. I'm not too sure which one it is. I think he had former attorney between they're retired, but maybe he's back at it. And he's brought to us a little seminar here. He's calling it Pulse Chain Law School. And these are his personal opinions and impressions of the filings. So what he says here is... Summary: the SEC's response brief was not written by attorneys confident in their position. Richard's briefs were. I will explain in excruciating yet still hopefully somewhat entertaining detail below. But first, let me remind everyone that the job of the court at the motion to dismiss phase is not to determine what's true and what isn't. Truth, justice, and all the other shit is for later in the case, if ever. For now, the SEC's job was simply to write a brief that saves their case so they can go forward in the hopes that they can eventually force a settlement and claim a win. Because their goals is scalps, not protecting crypto investors. Yeah, that's an interesting point there. They seem to be looking for the wins and not trying to further crypto industry in America, which they should be doing. Innovation, taking America forward. In the vast majority of civil lawsuits, this is a relatively simple task. Not so much here. So now this post was actually about a couple of months ago, but I saved it for this time because it's very interesting. So he says, in my opinion, there are some attorneys at the SEC who have to know by now that they will never be able to prove some or for all of the things that it's put in its complaint. But they don't actually care at this point in the proceedings, and honestly, neither does the judge. The concept is difficult for most people to grasp. This is why I've said it over and over again, hoping it flips the light for you all. Much like pimping, civil procedure isn't easy. A motion to dismiss simply argues that, look, judge, even if they prove every single fact they put in their complaint, it's still not enough to win on the law. What ROH's team is trying to point out is that the SEC didn't even bother to include certain facts in their complaint that would allow the SEC to move forward. On the other hand, the SEC's response has one goal: don't let the case get dismissed, no matter what it takes. If you want real talk at this stage, the judge doesn't even really give a shit whether any of the SEC's facts are true or whether even whether HEX PLS or PLSX are securities. This is why ROH's team doesn't spend a lot of time trying to point out how the SEC lied about something or everything, or do anything that more than a cursory analysis under the Howey test. It's a trailer, a preview of the upcoming events for the judge, so she knows what's going on to be next if the case stays alive. But those things are not necessary at this point to decide the threshold jurisdiction issue in ROH's motion. The only issue is whether the SEC has stated just enough to allow its case to move forward. So this is what the hearing's about at this stage. How could the truth not be relevant? What kind of effed up system is this? Valid question, but the sad reality of the situation is that the judge is required at the motion to dismiss stage to assume that the factual allegations in the complaint are true. Again, as I've stated many times before, it doesn't mean that those facts are true. It just means that for the purposes of a procedural motion, the SEC gets the benefit of the doubt, no matter how many times they simply made stuff up out of thin air and shoved it in their complaint. If you can believe it, there's actually a valid reason for it, and here it is. It's rare for any plaintiff that any plaintiff has all the evidence needed to prove its claims from the start, but it's common that the evidence exists. That's why the process is: number one, alleged facts you believe there is evidence somewhere to support; two, get the evidence in a discovery; and three, try to prove those facts in a summary judgment motion or at trial. A motion to dismiss asks the judge to evaluate whether the plaintiff did number one, step correctly or not before everyone moves on to step 2 and wastes money like they were government employees. My favourite analogy for motion to dismiss is a fat kid on an obstacle course. You may have heard me use this before. Right now the SEC is the fat kid trying to get over the first obstacle. Think of it like a big log lying on the ground and he has to haul his fat ass over. It's a low bar and most people get over it because literally all you have to do is point in the draft is a complaint that has basic allegations in it. You look to the elements of the claim and put in the facts that match each element. It's really not that hard. Anyway, if the SEC makes it over the log, they still have the rope to climb, the wall, and a dozen other more obstacles to get past. But they know, as all attorneys do, that the distance between a motion to dismiss and a trial is measured in billable hours. All attorneys know ways of dragging out the process, some legitimate or some not so much, and making the other side spend far more money than they need to. It's a tactic you learn early in your litigation career and you see over and over again. You learn which big law firms like to make your life miserable for no reason. I don't know what that case is, Fenham or Craik, by dumping tens of thousands of irrelevant discovery documents on your desk now and again in the hopes that your client will pull the ejection seat handle. Now, there's a few cases going on here in the UK, and there's a saying that they say the process is the punishment. So they try to make it so difficult for people to just not follow through with these cases. Right, moving on. You don't have to be a genius to see that this is the unspoken goal of the SEC in the crypto cases, to bankrupt companies and founders before their projects are successful enough to fight back. Library immediately comes to mind. I mean, if you're the government, you wanted to cripple the computer operating system software industry, you would it be better to file your lawsuits in 1979 or 97? Ideally, you want to bankrupt Bill Gates well before he has enough money to fight back. Not everyone in the government is stupid. They know that if they don't Tanya Harding the crypto industry now, it could very well be too late for another cycle or two. But boy, did they pick the wrong door with Richard. All that to get back to my original point, which is the SEC's response brief is not written by attorneys confident in their position. First off, the tone of their brief is defensive. It's pretty, at times, taking pot shots at the price of Richard's cryptos. Is price relevant to jurisdiction? Not in the least. What the SEC knows is that they did a shit job drafting their complaint, but they obviously weren't expecting Richard to hire a team of pie-pitters to point out every single flaw in it. As I've said many times before, if you draft a shitty complaint, you may get stuck with it. Here's hoping that that's the case here. Now, the SEC had to constantly reach outside of its complaint, something you're not supposed to be allowed to do, by the way, in order to try and justify its position. Did you read the BHAR declaration? I don't know what that is. The SEC repeatedly referred to in its response. Did you ever see or hear about that before now? Was he mentioned anywhere in the complaint? No. Pulling it out of the drawer now and dusting it off. It's not a sign of confidence by the SEC, and this declaration was horribly drafted. I mean, the bare minimum fact should have been included is where he lived, where he supposedly did what he did, whatever he did for Richard, because that goes directly to the single most important issue in Richard's motion. If you read it, it doesn't say where he lived back then, and the judges aren't allowed to just speculate on stuff like that. I mean, whoever wrote the declaration should be disbarred. Oh, sorry, the bar. Did you read the bar declaration? I'll see myself out. But seriously, folks, open Richard's reply brief and Control F bar, and you read the dozen or so things that the SEC could have or should have put in the declaration, but didn't. So why didn't he use it? I don't think they had any other choice. Their complaint is so deficient in alleging jurisdiction. I see that the bar declaration is running a play on 4th and 15th, but instead of helping them, it gave Richard's team more stuff to point and laugh at, which they did effectively. Key point here, I really need you to get this. Did Richard's team have to make one adjustment to their original April the 7th motion to dismiss arguments? No, they said what they said, and they didn't have to back off 1 inch from any statement that they made. Meanwhile, the SEC called audibles throughout its response brief, either adding stuff it didn't put in the complaint, modifying previous statements in the complaint, making irrelevant emotional points, or simply giving up on the arguments altogether. You tell me which team looks confident in their position. Yeah, that's an interesting point there. So they made lots and lots of changes, whereas it looks like Richard's team was solid right from the get-go, and they stuck to their guns. Very interesting point there. It's also why the SEC kept shoving Plex Corps in the Judge Amon's face. That is a crypto case in which she decided the issue of personal jurisdiction a few years back, finding that she could drag someone's sketchy ass into the US from Canada and beat him up in NY. The problem is that the facts of the case are so wildly different from anything Richard did that, if anything, it highlights the differences more than any similarities. But if the SEC had a better case to use, they would have used it. Since they don't, I think they're just hoping that the judge gives them a win on this issue once again for old times' sake. Then the SEC had to go back to its time travel argument in order to claim that Richard's statements from 2022 somehow had an impact on the offerings that took place well before then. You don't need to resort to obviously nonsensical tactics like this when you have the facts that support your claims. I'm relatively sure the judge knows how to read a calendar, so this probably wasn't the way to go. Next, if I'm a judge, can I tell from the SEC's complaint what percentage of investors in HEX, PLS and PLX are foreign versus what percentage of investors are from the US? No, I'm not allowed to guess either. Yes, I am required to take the SEC's actual statement in the complaint as true, but this isn't mid-labs where I can just fill in the blanks as I go. And this fact is pretty important when I need to determine whether something is predominantly foreign, don't you think? Finally, did you notice that many cases cited the SEC were easily torn apart by Richard's team? I don't know if you've ever seen the word aposites used that many times in the brief report. It actually is a masterclass of how to dismantle authorities cited by the opposing counsel. I wish I could have been this good at it. And it was done in a calm and professional manner, like the dude who took silver in the Olympics at shooting. Zero emotion, just systematic rivet by rivet disassembly of everything the SEC used to try to convince a judge of its position. If someone tore one of my briefs down like that, to the studs like that, I would have quit and opened up a beachside bar in Palau or somewhere nobody would recognise me. Still, to be honest. Okay, so where does that leave us? Obviously, the next big event is now October 31st. Looking forward to seeing a lot of you there at the Pulse Chain Tour event the next day. Will Richard win this motion? Who the hell knows? MTDs are disfavoured and therefore not often granted. Overall, they have like a 10% success rate, but that's not because the process is designed to favour decisions on merits, not dismissals on procedure. With that said, I like and have always liked Richard's personal jurisdiction argument, and I think that this one particular argument has more of a chance than most MTDs I've seen. And if he wins that, it's over. Nothing else in the case matters, because without jurisdiction, the court can't enter any orders or decide any issues. It just disappears. So that's the end of the course in that situation. Often, and your lawyer won't usually tell you this, motions to dismiss are filed not because your lawyer thinks the case will actually get dismissed, but for two other very important reasons. They generate billable hours for the attorney and also sometimes flush out evidence the other side has. Mostly the first reason, sometimes the second, but not here. Richard's MTD was filed because they legitimately believe that they can get the case dismissed, and that should be obvious from the amount of time and effort spent on the issue of jurisdiction. Still, you need to remember that they can be completely wrong and win, or you can be completely right and lose. Yeah, that's an interesting point. This is the reason appellate courts exist, so don't get too emotional up or down whatever happens with this hearing and the ruling. You typically don't win a game of chess in the first few moves. It takes you to set up the board, lure your opponent and into making bad decisions, and eventually take them down. And even if RH's motion is denied, he has to move forward. It's becoming clearer and clearer that the SEC doesn't really have the goods. I personally want nothing more than to see this case dismissed now, but if I can't get my wish here, I will honestly enjoy every single minute of Richard's team tearing apart the SEC for the next 2 years, and hopefully making a new and better crypto law that effectively neuters the agency's ability to go after digital currencies. Yeah, so even the long game, the long case may have a really good consequences for the industry. Not any legal advice. I could be wrong enough to know, but sometimes I get it right too. So peace. So that was an excellent write-up there, quite detailed, from Nuclear Herbs. Really good guy to keep your eye on. So the case is coming up very shortly, and we'll be interested to see what happens. Hopefully it just ends here and there, but if it doesn't, Richard has a great chance of winning this case.